We are here for CMC in the matter of CFI-071-2020 before Judicial Officer Maha Mehairi. The claimants are represented by Global Advocates and Legal Counsel. Lead counsel is Louis Wright. The defendant is the litigant in person, represented by Naeem Ahmed.
Okay.
Thank you.
Okay, please proceed.
Good morning, ma'am. I'm Louise on behalf of the claimants this morning of Global Advocacy. I believe before you joined the conference, the defendants raised an issue with regard to their representation. So perhaps the court may be minded that they may wish to hear from the defendant in that aspect before we continue.
Okay, Mr. Naeem.
Good morning. Yes, good morning.
Good morning.
Yes, madam.
Mr. Naeem is going to present himself in person.
Yeah.
Please proceed, Mr. Naeem.
Yes, I am. I'll be presenting my company on behalf of EASTLIFT. I'm the finance manager of the company. I'll be the representative of the company. Yeah, and Mr. Ali Qureshi is our counsel, and their firm is under process to register. Within a couple of days it will be registered with DFC, but we have already arrangement with them.
Okay.
Yeah. So do I have the authority to speak on behalf of the company, ma'am?
Yes, no problem.
Thank you, ma'am.
Okay. Ms. Louise?
Ma'am, it seems that you will have seen from the case management documents that there are quite a few issues in agreement, and I think it can be confirmed that if we address the point of mediation, well, the claimants have made attempts at mediation, and therefore we won't be inviting the court at this stage to make an order that parties should try to resolve matters through mediation, as it seems that has been exhausted, and there doesn't seem to be, whilst there is common ground, there doesn't seem to be enough common ground to meet agreement in mediation. So it seems that the only points in dispute that perhaps the court could assist with in today's meeting would be with regards to the court order. Mm-hmm. And the claimant notes that the first submission by the defendant is that they are asking the court to direct the claimant to put its case or expand upon the particulars of their case. Well, ma'am, the claimant submits that is a matter for the claimant in how it puts his case. The claimant has submitted a particulars of claim and will seek to prove its case through witness statements, and then will explain its position further in the skeleton argument later in proceedings. So we don't agree that the court, that there's any need for the court to direct the claimant to further particularize its case. So we don't agree that that is something that needs to be included in the order of the court. Mm-hmm. And the next point in issue is the dates are in issue at the moment as well, but if the court will allow me, I will come back to that point. But the next point in issue seems to be that the defendants believe that this is a case that is necessary for an expert report. And whilst, of course, that may be a matter for the defendant if it wishes to rely on an expert report, we note that they have included a direction in the order for the claimants to appoint an expert. And the claimants again submit respectfully that it is a matter for the claimant to put it how it puts its case. And at this point, with the evidence that is before us, the claimant does not seek to rely nor see that there's any merit in appointing an expert. So that is another issue that we are in dispute with over the court order. The dates, ma'am, the claimants are more than happy with the dates that the defendant has put forward, and if the case can be concluded sooner than the claimants had anticipated within their draft order, the claimants are more than happy to revisit that and agree with the dates put forward by the defendant.
Okay.
Ma'am, at this point, I don't seek to address you any further unless you have any questions.
No, I don't. Can I hear the defendant's side?
Thank you, ma'am. I think Louise has very succinctly put that the only issue appears to be the particularization of the quantum of the damages sought by the claimant. So in this regard, as long as there is a direction in the order that the claimant if the claimant is not willing to have an expert appointed, we are okay with that, because the opportunity is with the claimant. If they don't want it, it's their call. But nonetheless, as long as the claimant is there to prove that there is a way of proving the 9 million damages which the claimant is demanding, despite the fact that the claimant is still is the holder of the shares which were never transferred, or there was no need to go ahead with it. I'm fine with that, and the dates which we have recommended, as long as the claimant is happy with that, I think pretty much we are fine with everything.
I'm sorry, what's your name again?
Mohammed.
Okay, Mr. Muhammad, in relation to damages, if they haven't been supported by evidence or if they haven't been particularized correctly, then it will go to the judge and he will look at the evidence presented. If there is no enough evidence, then he will rule that it will be dismissed. So in relation to that, the court sees there is no need for them to particularize their claim at this point. If you think that after the disclosure of documents there is something missing, you can present it in an application, and the court is going to look at that application and give a ruling in that regards.
Fine, ma'am.
Okay. And as you said, you don't have any issues with the claimant.
The dates which we had suggested.
In relation to dates, if the court
fine with that, the dates which we suggested, so we're happy with that too.
Okay, then there is no pending issues.
No pending.
If there's nothing else the parties need the court to deal with, this case is going to be concluded.
Thank you, ma'am. There's nothing further from the claimant. Thank you.
Thank you, ma'am.
Okay. Thank you both for your time.
Thank you so much.
Thank you.
Thank you. Have a nice